So workers' compensation, if a lot of people in the industry, it's been referred to for years as the grand compromise. And what it means is the grand compromise between employers on the one hand and employees on the other. And it's really about the question is, why do we have workers' compensation laws and insurance? So this part of the presentation, I want to give a really, really brief history of how we got here today. And trust me, this will be short, but I think it's instructive as to why we have it and how workers' comp is very much different than other areas of the law. Let's say a traffic accident. Let's say you get involved in a traffic accident. Those kind of claims are handled very differently than a workers' compensation law or kind of a claim. So to understand where workers' comp came out of, it's to understand that if you look at Western Europe and the United States in the late 1800s, early 1900s, we were going through an industrial revolution. We were moving from a very agrarian society to an industrial society, meaning that the vast majority of people in the 1800s lived and worked on farms. And the Industrial Revolution, fewer and fewer people were living on farms. They were moving to the cities. Cities were becoming huge, and we were becoming primarily an industrial society. And out of that, there was a lot of brand new, dangerous machinery. Really no safety considerations were brought into it. There were large numbers of accidents and deaths, and it was pretty egregious, horrible time to actually kind of live and work. And at those times, prior to workers' comp, if an employee was injured either in a construction site accident or at a manufacturer, they really didn't have a lot of recourse against their employers. Oftentimes, they were found at fault for their own accidents. So put yourself in your shoes that before there was workers' compensation laws in the United States, put yourself in the shoes of an employee and you're injured at work. It doesn't matter if you were at some sort of a plant, if you were working some construction site, whatever, what would happen to you? Where would you go for compensation? Well, if you were injured on the job site or in the plant, to get compensation for your medical bills, your lost wages, if you want to make claim for pain and suffering, the employee would have to sue his employer in civil court. You'd have to go down to the courthouse, file a lawsuit. And the vast majority of these kinds of lawsuits were unsuccessful. And it was primarily because the employers had some pretty potent legal defenses that stopped the employees from getting any kind of compensation. One of those defenses was contributory negligence. The argument that, well, you as the employee did something to cause your own injury. You acted unsafely. You were not paying attention to what you were doing. And therefore, you employee, your negligence is greater than my negligence as the employer. Therefore, I don't owe you anything. And that was the first event. The next one is an assumption of risk. And it basically goes like the employee, you're working in a factory where there's dangerous equipment, or we're blasting granite out of a quarry, and there's a high risk. And you're going in there, employee, you know that there's a risk there. And as a result, if you're injured, you're assuming that risk and the damages that come from it. Oftentimes, this was built into a written employment contract that would say you're assuming all risk for injury from your workplace. And this is a fairly effective block for an employee suing their employer. The third one was the fellow servant rule, essentially saying if your coworker causes an injury to you, let's say they drop something on your foot or run you over with a piece of machinery, well, your claim is against your fellow employee, not against the boss. Of course, the guy that ran your foot over probably is just as poor and destitute as you are, doesn't have anything to sue off of anyway, or to go after anyway. So those three defenses performed a pretty good barrier for employees at the time. Well, that's kind of the state of affairs for several decades in the 1800s and early 1900s, but then attitudes started to change in the early 1900s. There's a whole bunch of other things going on, and work comp was sort of fit into one of those things. And juries were starting to rule more and more in favor of employees. So employees started getting more and more judgments in their favor. There's the other issue and coupled with that is when it comes to liability damages, there's really no limit on liability damages. You can get pain and suffering could be a huge number in certain cases. Wages for the rest of your life, medical bills for the rest of your life. It's open-ended to some extent. And even if you won as an employer defending these cases, they're just like today, hiring an attorney is very expensive to defend a lawsuit. It was just as expensive back then, relatively speaking, and they're expensive to defend. So even if you won, you still paid a lot of money. And this was all going on at the same time in the U.S. and Western Europe. Germany actually in 1884 was the first country to come up with what we recognize today as the workers' compensation law. And it was Otto von Bismarck trying to unite all these little German states. And as part of that, he created a social safety network, which looks a lot today like our workers' compensation laws. Switch over to the United States, and prior to 1911, there were 4 states that had passed workers' comp laws: Maryland, Massachusetts, Montana, and New York. All of these were struck down as unconstitutional. In fact, New York was struck down on March 24th, 1911, and one of the biggest opponents at that time were the labor unions. Again, that's labor unions at that time were opposed to it because it felt that it may make them unnecessary to the workers. So they were very opposed to it. They often sued to have these things struck down, and they were struck down. Now, the day after New York declared their law unconstitutional, there was this thing called the Triangle Shirtwaist Fire, March 25th, 1911. Just like it sounds, it was a garment factory in New York, in New York City. Somehow, I forget how it happened, but a fire started, and 146 workers were killed, almost all women, because this is seamstresses and people working with cloth, and that's how many people died. And big national news, obviously, big tragedy. Eventually, families sued and settled for about $75 each back then, which today's dollars is about $1,900. But what came out of that was a new push to enact workers' comp laws. And later that year, Wisconsin became the first successful workers' compensation law. And a lot of other states followed shortly thereafter, so that by 1920, most states had some version of workers' comp. And today, what's great is once you understand how one system works, and Wisconsin being the first one, became kind of a template for a lot of other states. So once you understand one workers' comp law, how it is generally structured and the general kind of benefits you can get, it's a lot easier to understand, for example, Illinois, Minnesota, or some other states. There's obviously some differences, but once you understand the basic structure of it, it's a lot easier to understand the whole. So that's what once you learn one, easier to learn the others. So what is the Grand Compromise? What do these workers' compensation laws actually seek to balance between the employees and employers? Well, the employers and the employees gave up certain things, and they both got certain things. For example, the employers gave up those 3 negligence defenses that I talked about. They said, nope, we don't raise that anymore. The employees gave up the right to sue in the court system. They don't start there in the court system now. They deal with it typically as a government agency. They gave up the right to pain and suffering damages. They can't get those under workers' comp. And they gave up the potential of unlimited damages, which is like full wages for the rest of their life, let's say, or loss of consortium claims presented by their family members. If they're severely injured or killed, their family members don't have what are called loss of consortium claims. So that's what the employees gave up, a serious amount of damages for the trade-off of these negligence defenses from the employers. So what do the employees receive? Well, first, now they have defined benefits described in the law, and it's all based upon a no-fault system. Negligence and fault really do not play into this. And they have their defined benefits, which we're going to go through in a little bit here. The other thing they got was if they're injured and they're off work, they get more or less what I would call immediate payments for lost wages and their medical bills. Now, that's very different than in what I would call tort law or negligence law. For example, if you're in a car accident with somebody and they cause the accident and you're injured, if you go to them with your medical bills and lost wages, they'll say, no, we don't pay the bills as we go. We pay when you sign a release. And if you're injured enough, that's going to be a while, and that can be a real economic pressure. But contrast that with workers' comp. Workers' comp says, oh, your medical bill is related to your injury, no question about it. We have medical support for it. We just pay the bill right away. Same thing with the lost wages part of the claim. You're off of work, you get a check the next week. So that's one of the things that the employees received. Also, a much more streamlined dispute resolution system. And what did the employers receive? Well, they now have exclusive remedy protections. Employees have to go through the workers' comp system. They have limited benefits now. That's their exclusive remedy. The employers received some limited liability exposure for damages. All these damages I talked about before, now the employer doesn't have to worry about that. It creates a much more predictable in terms of financial outcomes. It's you can budget for it. You can project out how many claims you'd expect to have and what those costs are going to be. It also reduces the amount of defense costs. It's much cheaper to defend a work comp claim than it is a lot of other claims that go into circuit court. It also created an instantaneous insurance marketplace to spread the risk of loss. Just like any other insurance, you pay your premium, and that's all you pay. The insurance company takes the risk of the full loss. There was no insurance marketplace before that for this. The laws created this new marketplace, and employers benefit from the more streamlined resolution system